Please tell us your name and your roll number for this exam.
So my name is Swagatika Swain. The roll number is 101099.
Will you please speak in few words about your academic career?
Yes, sir. So I have completed my schooling from KV Khordha Road in the year 2009. So thereafter I have completed my +2 from PN Junior College. Then I pursued my BBA LLB from SOA National Institute of Law and LLM from SOA National Institute of Law in the year 2018.
So are you practicing now?
So not practicing.
But 2 years experience is
so yes, sir.
no?
So yes, sir. When I got membership in criminal bar, thereafter the COVID enters and everything becomes halt. I frequently go to the seniors chamber. So,
But you are continuing, eh? You are continuing.
yes, sir.
So
Sir, for presently,
you can confirm that yes, I am continuing. I am a pleader now. That is the main thing.
You should say that I am practicing, but
practicing. The corona, other things I should do speak. There is no need to speak. Do you know after being selected as assistant public prosecutor, what you have to do? What will be your responsibilities?
yes, sir. So the responsibility lies in both the stages, in investigation and in the trial. Sir, in the investigation, after the completion of the investigation, the when the police officer submits the charge sheet to the magistrate, the public prosecutor will assist at that time. And in the trial, the prosecution has to argue on the behalf of the state, being the state officer, and has to establish the case beyond reasonable doubt by proving all the ingredients of the cases after considering everything, every evidences and facts. Not only that evidence, not only giving the justice to the accused, justice to the victim, but also giving the fair treatment to the accused too.
okay. With whom you were associated? Where?
Sir, Chinmay Mohanty.
Okay.
Mr. Chinmay Mohanty is a criminal lawyer.
Okay. So, what is 317 CRPC?
So 317 CRPC talks about recording of the evidences in the absence of the accused.
317 of CRPC.
Yes, sir. 317 talks about evidence recording in the absence of the accused. Like the presence of the accused is dispensed with.
Accused is presence of the accused is sought for to be dispensed with.
Yes, sir.
The representation represented by a lawyer.
Yes, sir.
Okay. What is 205?
So 205 is also talks about the dispensation of the accused in the presence of the pleader, or subsequently that if the court directs, the presence of the accused can be enforced.
Achha, suppose in a criminal trial, can we dispense with the recording of statement of the accused statement? Can we dispense with?
Sir, now the question arises in both the stages, like in summons case and in warrant case. In summons case, once the dispensation of the presence of the accused is dispensed with, the dispense of his presence is totally dispensed till the trial. And in the warrant case, he has to come before the court for the recording of the statement.
That means you say that his statement may not be required to be recorded if it is a summons case and his presence has been dispensed with.
So from the very beginning, if the presence of the accused is dispensed with, subsequently his presence will be dispensed with till the trial, and if necessitated, if the court necessitated, he can direct for the presence of the accused before the court.
Yes, at what time the state, what is the time, hour by which the state has to be taken in the court, lower court? Have you ever taken step?
Sorry sir, I am unable to answer this.
We have not, never.
No, sir.
That's
Tell me, as a general rule, whether opinion can be a relevant fact.
Yes.
General rule.
Okay, ma'am. General rule is that it is the opinion of a person who is especially skilled in certain areas. In that case, the opinion of the expert is necessitated, which is
So, what is the general rule as to opinion? Whether it is accepted as an evidence or not? Generally.
in a case Murali Lal versus State. In that case, it is specifically given that once there is contradiction between whether the opinion of the expert will be taken or not, or if that evidence of the opinion is in contradiction with the opinion of the expert, then it is the discretion of the court. The court will allow
That will be the evidentiary value of an
yes, that the court will allow to do that.
That is subject to corroboration and contradiction. I am asking you, if there is a witness coming to the court and his statement is like, in my opinion this happened or that happened, whether that will be taken as an evidence? Opinion whether can be an evidence or not. This is what I am asking. I am not going to the part of expert's opinion. I am just asking whether a judge will accept an opinion of a witness.
Explain. If an opinion of a person is corroborated with other facts, then in that case the court will accept.
So generally opinion is relevant. So anybody coming to the court and giving his opinion as to any fact can be accepted if it is corroborated.
If it is corroborated and it is relevant to the particular case, in that case the court will allow.
So if my opinion is connected with her case, then that will be accepted as an evidence. This is what you are saying, right?
Now the court will see the evidences. After taking the evidences, after analyzing the facts, whether the things that are
Okay. Tell me, what is Section 5 of Indian Evidence Act?
Section 5 of the Evidence Act talks about of what things the evidence can be given, of a fact in issue, of relevant fact, and of no others.
Okay, so facts in issue, relevant fact and no others, right? Relevant fact I understood, that will be coming under 6 to 55. Give me an example of the first rule, fact in issue. Give me one example where this can be taken as an evidence. Give me an example of a fact which is coming under that first rule.
Thank you, ma'am. The first rule is when I am giving an example, when the question arises that whether A has committed the murder of B or not. Thereafter, the certain issues arises. Whether the accused has planned previously in order to commit murder, the issue arises. Whether he has prepared something in order to commit the murder, or certain issue arises. Or accidentally caused the murder. These all are the issue will arise in the case.
Right. So, how this will be an evidence? Section 5 says about what facts are evidence, right? What can be taken as an evidence. So, it says if it is relating to the facts in issue, then that will be considered as a relevant fact, evidence, and the relevant fact itself can be given as an evidence. My question is, give me an example where a fact will be coming under that first rule and can be taken as an evidence.
The thing which are not coming under the 5 to 55 and that is relevant as an issue, then in that case the court will allow to be taken.
Okay. Tell me one more thing. If there is a co-accused and giving a confession, what will be the evidentiary value of the confession for the other accused? And what will be the evidentiary value of confession for himself who is giving the confession?
Okay. Yes, ma'am. So, ma'am, when the co-accused is giving the confession, and he is about the facts and circumstances of the case in which he is involved in, then after giving the confession, the co-accused will become the approver. And approve it is coming under one maxim, participes criminis. He would become an approver.
So what is the evidentiary value? Confession as the evidentiary value of confession of an accused person for himself and the other accused person.
Yes.
Just tell me whether it is a corroborative evidence or a substantive piece of evidence, what will be the evidentiary value of that confession for the person who gave that confession and for the person, the co-accused, right? The other person who has committed offense with him.
As per section 30 of the Evidence Act, once the co-accused is giving the confession, against himself and against the other person, that will be validly accepted.
Accepted?
Provided the person should be in a joint trial.
Yes, but what is the evidentiary? Whether it's a corroborative evidence or a substantive piece of evidence?
That would be taken as a corroborative evidence.
For himself and the others also. And if the confession is used against the person who has made the confession, then also that will be taken as a corroborative evidence. Right?
Confession from the very beginning, that is, it is saying that admitting the guilt.
Right.
That
so whether confession cannot be a sole basis for conviction?
Conviction can be sole basis of conviction, provided it has to be truthful and.
So if it was truthful, the person who gave the confession, it was truthful, it was to judicial magistrate, it was under every possible conditions been fulfilled. Then now tell me whether that can be a corroborative evidence or a substantive evidence for the person who has given the confession for him, whether it is substantive or corroborative, who has given the confession. Suppose A is giving the confession, B is the other accused, right? For A, whether that will be substantive or corroborative, if you are using that against A.
For B, if B is giving evidences for him, it is coming under the relevant fact, and coming under the relevant fact. That means for the opposite party, it would be corroborative evidence. For him, it would be just confession.
So know one more thing. Whether a statement can be a conduct, mere statement.
Ma'am, as per section 8, which talks about when the conduct would be relevant, only a statement is not relevant unless and until it is accompanied by the explained acts.
What do you mean by that? Give me an example.
Yes, ma'am. Ma'am, here the example is after commission of a crime, a person went to the police station and given the FIR. The statement which is made in the FIR is explaining facts, and the conduct of going to the police station and making the FIR is a conduct. The conduct explained with the acts.
So conduct is relevant of only accused person or some other persons also?
His conduct, his previous and subsequent conduct is relevant.
I am asking you whether a victim's conduct is a relevant fact.
Basing on the case, if the case demands.
What is section 8? What this is about?
Section 8 talks about the motive,
Right.
preparation, conduct. Whether
So motive and preparation is related to accused person only, right?
both.
Motive and preparation. And conduct, whether it is only relates to an accused person or conduct of any other persons is also relevant. This is what I am asking. Preparation, I understood. Accused person prepares for an offense. Accused person has motive. Whether conduct of an accused person is only relevant under section 8 or victim's conduct is also relevant, party's conduct is also relevant, agent's conduct is also relevant.
So, ma'am, conduct is conduct of the accused, conduct of the agent, and conduct of the agent of the parties.
How you differentiate between motive and intention? Whether in a criminal case, if there is a proof of a motive but no intention has proved, but there is a fact which is indicating the motive of that person but no indication as to his intention, then whether he can be still held liable? There is an evidence of motive but intention has not been clearly proved. So only on the basis of the fact of motive whether he can be convicted. There are some other evidences also but intention has not been proved. Mainstay is not there, but there is motive.
Yes, ma'am. Ma'am, if there is no intention and there is motive, then in certain circumstances the motive would be relevant, provided the other facts has to be supported with.
So you are saying without having mens rea, a person can be convicted if there is motive. If suppose A's motive is that it has been proved that if A is killing B, he will be getting 500 crores rupees and of that person, right? As a legality or anything, any of sort that fact. So tell me whether that fact only is relevant to convict A. Only on basis of motive, no mens rea needed. Because that's the base of criminal law, right? We have only two elements. One is actus reus, another is mens rea. So I'm asking you whether that mens rea refers to motive or intention.
Ma'am, motive is ultimate.
Just answer me yes or no. If there is no proof of intention and there is a proof of motive, whether a person can be held liable, yes or no?
No.
Thank you.
Thank you, ma'am.
ଆପଣଙ୍କର ବସ୍ ଆପଣଙ୍କ ବସ୍ ଗୋଟେ ଜିନିଷ ପ୍ରୋବ୍ଲେମ୍ ହେଉଛି ଆପଣ ଡିରେକ୍ଟ ଆନ୍ସର ନ କହିକି ଆପଣ ଟିକେ କନଫ୍ୟୁଜ ହେଇଯାଉଛନ୍ତି as to provisions, right? If I'm asking you something, don't go to the provisions because we know the provisions, right? We are only expecting that answer. So ଆପଣ ଆସିଛନ୍ତି APB ପାଇକି ମାନେ you know the things, right? Written you have qualified. So only stick to the point what has been asking to you. सेटा गुडे जिनसे मार्क करियो था ठीक है सेटा के देखियो
unnecessary provisions make a confusion जानि छै सब्जेक्ट है कहदा
मैम मो प्रोविजन नाउ एक्सप्लेन करिवेनी
हां बेसिक एक्सप्लेन
नहीं आंसर ता करी तपर करियो
नहीं देयर इज अनदर थिंग जो माने जो जुडिशियल जो ना जो इंटरव्यू करूछथि समान को नॉलेज जे पिला माने बुकीज अछथि एवं केवल प्रोविजन को रिलेट करले पटकिन कहि दोछु तो सेहि पे प्रोविजन खोजुछथि तो सेमाने चाहूछथि जे यूटिलाइज करथिबो पाठटा को तार डे टू डे लाइफ रे बा बुझिथिबो से सेटा न जाय कि सिचुएशन ता कहबो बा लॉ ता कहबो आउ जने प्रोविजन ता को रिलेट न कले कहबो तेनो सब बेला प्रोविजन को पढा जतोल पछेरिबे व्हाट इज द प्रोविजन देन इट्स अंडरस्टूड यू मास्टर करछ प्लस बुक ता भी बोलर करना करछ
मैम से जो क्वेश्चन ता पछरले मैम से आंसर
सी directly motive cannot be taken as an evidence. It's a very different thing. It's a relevant fact. Intention is something which foreknowledge of that it's foreknowledge of that person while committing the thing. मुझे तो जब कुछ छुरी भुसुची I know that मैं छुरी भुसुची, right? That's my intention. That मैं जानी ची मैं कौन कर ली. Motive is for what I am doing, right? कि मुझे को मारे दिले मत ता property मिलियो. But गुड़े केस रे कहला prove है कि लेकिन ताको मारे दिले ता property टा से न हो. But ताको मारिए रे तेरे इच्छा थिला ना नहीं. Whether that is most important thing or not. तो आम पाखे फैक्ट अच्छे मारिले 500 कोटी टका तक पड़ेगा. बट सर मारी ची ना नहीं तार इंटेंशन थिला ना नहीं हमें जाने. फॉर एग्जांपल से गाड़ी चलुथले से लोकड़ा पर गाड़ी चढ़ी गला. तो हमें जान से मारिले 500 कोटी टका तार. तो गुडे आम मुंडल कौन फ्रेम होबो कि हां मोटिव थिबो कि ना 500 कोटी टका तार. बट ओनली ऑन द बेसिस ऑफ दैट वेदर ही कैन बी हेल्ड गिल्टी जदि तार इंटेंशन हमें प्रूफ करने की ताको मारियो की इच्छा थिला. बिकॉज़ मेंस रे इज एन एसेंशियल एलिमेंट, राइट? इट इज ओनली एक्टिव रेस मारियोटा ही गला किसे चढ़ी गला. बट से चढ़ीटा जान थिला ना नहीं. Whether he has the intention to kill that person or not, then only he will be liable. Only on the basis of motive he liable here. But you can say like this: if there is a case where there is an evidence of motive, that may refer to the intention of that person with other corroborative evidences. बुझे? खाली motive रू तो intention prove होबनी. But जब motive से तो अलगा भी corroborative evidences होसी. जोड़ा कि गुड़े circumstances create करची and circumstances is so like it chain gote form koruchi कि there is no other view कि से मारी नथियो. It is in all probability indicating the guilt of the person, right? So intention रे दीटा जिनस गोटे directly prove होची intention he will be liable या तो गोटे circumstantial evidence रे. And circumstantial evidence से पूरा chain formation हितवे नहीं हिते दरकार. Only motive cannot form the complete chain, right? Okay.
ठीक है.
So
thank you.
Thank you, sir.